Good evening, everyone. This is Wendy, and you're here at Truly Sinister. Thank you for joining me. Today is what is today? Thursday. I got called off tonight, so I thought I'd come on and start talking about a new case about a young lady, 22-year-old. From Michigan, Wexford County, Michigan. She was 38 weeks pregnant, which is a viable fetus, basically. It's a baby. You can go into labor at 38 weeks and the baby will be fine. Most likely won't need any kind of intervention or anything. Maybe just a feeder grower to gain a few pounds before they go home, but ultimately it's a viable baby. So 22 years old, 38 weeks pregnant, and she's lured to her biological mother's house and by her stepfather, where they torture and unalive her and basically try to remove the baby from her stomach, and the ultimate result was the baby and the mother both were killed. So we're going to start covering that case, and so I have a couple of articles that I wanted to go over about it. Originally, she disappeared on November 3rd, I believe, and her sister and her fiance were both arrested within a day of each other in November. The fiance was arrested on unrelated charges of delivering methamphetamine, and her sister was arrested for tampering with evidence, giving false information to a peace officer, and I can't remember the third charge, but they said that they're not saying whether or not her charges are related to the abduction and torture of her sister. However, she did, when they brought her in for questioning during her arrest, she did give them information as to what happened to her sister. So I'm kind of thinking that yes, she's involved, or they think she's involved, and the charges are related. So there's that. So anyway, and I did look up the Wexford County Courthouse. They basically, I guess her mother and her stepfather were arraigned this last Tuesday, as in day before yesterday, and that's before I knew about the case, so we missed the arraignment, but apparently the court was just full of family and community members of both the mother and the victim, because obviously it's her biological mother. But they were there many of them stated that they were there for the victim, Rebecca, rather than the mom. And that says a lot. It's crazy. I mean, what the hell were they thinking? I mean, whatever. I can't get over what some people are capable of. And it's like, if the stepfather talked the mother into it, shame on the mom. Shame on the mom. How can she let a man come between her and her daughter? Apparently, her name is Rebecca Park. The victim's name is Rebecca Park. She's a beautiful young lady. It doesn't say whether or not her fiance is the father of the baby. And since they aren't saying, I'm kind of assuming maybe he's not. But I don't want to speculate, so let's just nip that in the bud. But you got to see these people. They look like their family tree is a wreath, to be honest with you. I mean, Rebecca looks like the most normal one in the family, and she's gorgeous. So apparently her biological mother did not raise her. She was raised by another family that adopted her and her siblings, and I'm not sure how many siblings she has, but So she was raised by somebody else. She wasn't raised by her mom. So maybe her mom didn't feel any kind of loyalty to her. I don't know. It's just, it bewilders me. But before we get into this, ask if anybody's watched the Brian Walsh case today, or trial today. I did, and I saw that William Fasto was on the stand. Boy, he seemed angry, didn't he? He seemed really hostile almost. He just had this look on his face, and there's just something, there's an underlying vibe I got from him that not sure what to make of it, but I didn't really much care for him, so, But they went through a lot of witnesses today. Keefe, what's his first name? State Trooper, MSP Trooper Connor Keefe testified today, and it's going to be interesting to see how much they rely on Cellbrite and whatnot, because they were saying how undependable it was, and unreliable, and how you couldn't depend on Cellbrite findings, in the Karen retrial, that is. But I have a feeling they need to depend on the Cellbrite findings in this trial, and they're going to have a hard time with Attorney Tipton, because he watched the Karen retrial. He's very into it, and he followed that trial very closely, and he's going to call them on a lot of their bullshit, I think, so I can't wait to see it. I don't know, I didn't get to finish watching today's court hearings, or the trial. I think I got through most of the direct of Connor Keefe, and that's it. I got up to that. So if the defense started cross-examining him today, I didn't see it, so no spoilers. But I will catch up on it tonight. So, here we go. So first I want to introduce you to... Oh, and then at the end, I think there's a couple of new things on Aaron Spencer's docket. So at the very end, we'll go over those. There were nothing major, but I still want to cover them. Okay, so, let's go back to StreamYard. So I want to share my screen. So this is Rebecca Park. This is Rebecca Park's sister, Kimberly Park. And this is Rebecca Park's fiance, 43-year-old Richard Vaylor, I believe his name is. Yeah. Wow. I mean, I just don't even know what to say about that. I mean, that's mean. I shouldn't be like that, but holy crap. I mean, how do you, Jeez. Anyway. So, let's get into this one. This is by Law and Crime. This background is where her body was found. It's Manistee National Forest in Baldwin, Michigan. This is where her body was found. This is a trailhead. It is now right now closed, and I'm not sure if it's closed for the winter or if it's closed because of the crime scene, but yeah, that's where her body was found. The fiance and sister of a missing Michigan woman are behind bars after searchers recovered a body resembling the missing woman. Rebecca Park, 22, was last seen alive by her mother outside of her home near Cadillac on November 3rd, according to law enforcement in the Wolverine state. Now, I don't know if they mean her mother, her adopted mother, because I think she was adopted pretty young, so she probably considers that her. But I'm not sure if that's who they're referring to, or if they're referring to Courtney, her biological mother. I think it's her adopted mother. Okay. By her mother outside of her home near Cadillac on November 3rd, according to law enforcement in the Wolverine state. That day, she had just received $2,000 in inheritance, was getting into a vehicle, and was 38 to 39 weeks pregnant. On November 25, a body was found by searchers along a hiking trail in the Manistee National Forest in Boone Township, a tiny municipality located roughly 35 miles due south of Traverse City. The young lady, quote, the young lady that was found resembles Rebecca Park, the young lady who went missing on November 4th, and we are actively investigating that, end quote. Wexford County Sheriff Trent Taylor said after the discovery in comments reported to by Detroit-based Fox affiliate WBK. It's, quote, it's a tragic time in our county, and hopefully this brings some closure to this awful incident. How can it bring closure? It's just starting, basically, right? I mean, yeah, our body's found, but now you have to find who's responsible, prove it, and get them off the streets. Get justice. Later that same day, at around 9 p.m., Park's fiance, Richard Fowler, 43, so she's 22 and he's 43. Could they possibly have in common? Was arrested on multiple charges. Then, hours after that, during the early morning hours on November 26th, the missing woman's sister, Kimberly Park, 21, was also arrested on multiple charges. Fowler stands accused of 2 counts of delivering methamphetamine. I don't know if I'm supposed to say that on here. Well, too late now, huh? Kimberly Park stands accused of 1 count each of tampering with evidence in a criminal case, lying to a police officer during a violent crime investigation, and filing a false report of a felony. So that, lying to a police officer or during a violent crime investigation doesn't get more violent than what Rebecca went through. So I'm pretty sure it has to do with her sister's death. As of this writing, there's no formal indication that charges are related to the disappearance of the older Park sister. Okay. And while an autopsy will be performed on the human remains to confirm the identity, family confirmed the body found in the forest belonged to the missing woman. During an arraignment on Wednesday, the sister's bond was set at $750,000, while the fiance's bond was set at $1 million. Now, if they weren't related to this case, why would their bail be so high? And listen to this. Both defendants were deemed threats to the community and flight risks, according to courtroom report by Kalamazoo-based CBS affiliate. So, yeah, you don't want them to flee or anything like that, but a danger to the community, they've got to be involved. Or they must be suspected of being involved, and their arrests, I think, have something to do with the death of Rebecca Park. But then, citing national media attention, 84th District Court Judge Corey Wiggins shut down broadcasts of the proceedings, according to Traverse City-based NBC affiliate. Oh, that sucks. I wonder if they're not going to let any broadcasts. I wonder if they're going to refuse broadcasts of the whole thing or just the arraignment. Because I had just told you that I looked it up and they do broadcast, they do stream their trials there. So that county streams their courts, live streams their court hearings and trials. Wow. Quote, Kimberly Park, ladies and gentlemen, people in the court, media, and those on live stream, end quote. The judge said, according to a courtroom report by WIBK. Quote unquote, this court has an ethical duty to ensure that the defendants in these cases can have a fair trial. The court is well aware of the publicity this case has received across the country. In order to protect the defendants' interests in this case, the court is going to take the court off of. Wow. Law enforcement are keeping, so they're only going to live stream cases and trials that are unimportant to the public. Is that what they're saying? If it draws attention, they're not going to publicize the hearings and the trials, but if nobody's interested in them, then they'll stream them live. That hardly makes any sense. Law enforcement are keeping mum about the state of the deceased woman's child, or even if a child was recovered along with the body. Rebecca Park's due date was November 18th, according to People magazine. Oh my God. Quote unquote, I'm heartbroken, crushed, Rebecca Park's adoptive mother told WWMT after the cascade of recent events. I have to remain strong. I have 3 children, little biddies that do not understand any of it. We have been, as a family, preparing for this outcome. Not quite as gruesome as this outcome, but preparing for this outcome. End quote. Wow. That's terrible. I just don't get it. I don't understand where people's mind is at when they are doing shit like this. Maybe this stuff like this has happened forever. We just didn't know about it because we didn't have live streaming and we didn't have the internet, we didn't have social media. All we had were newspapers and magazines and the news on TV. So you just didn't hear about this stuff. Maybe this kind of stuff has been happening forever. I don't know, but it just seems like there's definitely a rise on these types of crimes, these gruesome crimes. Okay, so this is going to be a short stream. So let's see if I can't get a few more watchers if I make these shorter until I get more viewers, and then I'll do more longer lives, I guess, because I just don't know what to do. Okay, so this is an article out of, okay, it was written by Harry Codbum. I don't know, I can't read it. From The Independent. Okay. I have to get you guys on board, sorry. So, evil personified, mother and stepfather of murdered pregnant woman accused of cutting baby out of her. Rebecca Park was reported missing on 4 November, and her body was found in Woodland on 25th November, while her baby's body has not yet been discovered. I didn't realize that. I thought they found both of them. I didn't realize they hadn't found the baby yet. Maybe they have by now, I don't know. Wonder who they were cutting it out for. Were they going to sell it were they going to traffic it? Were they going to sell it for drugs? I mean, what were they going to do with the baby once they had it out of her womb? I mean, her mom's too old and too run down she couldn't even raise her own kids. Why would she try to raise this kid? So here we go. A couple from Michigan has been charged with the murder of 22-year-old Rebecca Park and her baby. After allegedly, they must have found the baby, otherwise they couldn't be charged with the baby's murder, right? because you don't know, maybe if they didn't find the baby's body, you would have to think maybe they got it out alive. So I'm thinking they found the body now, and that's why they're being charged with both murders. After allegedly luring the pregnant woman to the woods and cutting her baby out of her body. Courtney, I always say Mule. Courtney Bartholomew, 40, the victim's biological mother, and Bradley Bartholomew, 47, her stepfather, faced multiple charges, including murder, torture, unlawful imprisonment, and the removal of a dead body. A significant search effort involving the local community in Boone, Wexford County, was launched after Park went missing just days away from giving birth. Her body was found in the nearby Manistee National Forest, close to the shores of Lake Michigan, north of Grand Rapids, but the baby's body was not present and has not been recovered. So they haven't found it. Wow. According to the authorities, on November 3rd, the Bartholomews lured Park, who was 38 weeks pregnant, to their home in Boone. This is them. That's her stepdad, and that's her biological mom. Ew. She was then reported missing on November 4th and had last been seen the day before entering a vehicle at her mother's house, her adopted mother's house. The couple then allegedly drove to the forest where they tortured Park in an attempt to remove the unborn baby, resulting in the death of both. Now, how they know that they both died, I don't understand that, how they know that, unless they confessed. The pair then left her there. Wexford County Prosecutor Joanna Carey told the court during the Bartholomew's arraignment hearing on December 2nd. After an extensive search, Park's remains were found on November 25th. This is, frankly, evil personified, quote unquote, Carey said. In a statement, Carey added, quote, "This case involves a truly horrific homicide in which a young woman and her unborn child endured unimaginable suffering at the hands of the defendants," end quote. Quote, "The brutality and disregard for human life displayed here are deeply troubling, to say the least. While these remain allegations until proven in court, the evidence reflects an extraordinary level of callousness and violence. We look forward to presenting the full facts in court," end quote. That's Rebecca. Michigan Attorney General Dana Nassau said, quote, "Rebecca had everything to live for, and our hearts are with her loved ones as they endure this unthinkable loss," end quote. "We are committed to working alongside the Wexford County Prosecuting Attorney's Office to ensure justice is pursued in this tragic case without delay," end quote. Two other people connected to Park, though not accused of her murder, have also been charged in recent days. Kimberly Park, Rebecca Park's sister, is charged with tampering with evidence, lying to a police officer, and false report of a felony after allegedly telling police that the two family members struck Park, quote unquote, in the head, causing a seizure, and then took her body away. So she was there. Richard Fahler, identified as Park's fiance, was charged with 3 counts for controlled substances, delivery and manufacturing of, and a habitual offender, 4th offense notice. He pleaded not guilty in court on December 2nd. So don't they have 3 strikes there? I don't know. The brutal murder has shocked the close-knit community, which reportedly packed out the courtroom to hear the charges against the Bartholomews read out. Many attendees decorated their cars with messages including, quote, say their names, end quote, justice for Becca and Baby Park, and we are her voice, the Detroit Free Press reports. As people left the courtroom, Stacey Davis, Bradley Bartholomew's estranged sister, told the Detroit Free Press that her brother had always wanted to, but the couple couldn't conceive one, so they were going to keep it for themselves. How are they going to explain that? How are they going to explain having a baby all of a sudden? Just one day show up to a family function with a baby? Her 38-week pregnant daughter goes missing, and all of a sudden they have a new baby. I mean, what are they thinking? How do we get here? She added, quote, I'm here for Rebecca and her baby. I'm not here for my brother, end quote. You go, girl. So, it doesn't look like they're going to be streaming that case, but we're going to follow it closely because it's heartbreaking, and I want to see justice for Rebecca and her baby. I mean, it's really unthinkable what people are capable of. And your own blood relatives. I mean, granted, she didn't raise these kids, or her, Rebecca and her siblings, but how do you still, I mean, even if they're not your blood, how can you do that? You know what I mean? Much less they're your own kids. I mean, what in the hell? I thought for sure they were going to sell it for drugs. They just looked like that kind of people. This is another picture of Rebecca. Isn't she gorgeous? That's so sad. It's heartbreaking. So young. And I showed you a picture of her brother, or her fiance and her sister, and that's her. Isn't she beautiful? She's very pretty. It's just, I mean, just goes to show you how being raised in a loving household and nurturing affects how you turn out in life. Because look at her mom, for crying out loud. I mean, you know what I mean? It's like, here's a picture of all three of them. It's like, what the hell? I mean, look at them compared to her. You would never know that she was the product of this woman. She was just a oven for Rebecca's farm. Oh, you guys aren't even seeing what I'm looking at. I'm sorry. Okay, here we go. I'll show you again. Start over. This is Rebecca. Sorry about that. So this is Rebecca. Is she gorgeous? And see if I can get them all on the same page. It doesn't look like it, so I'm going to have to go out and come back in. And this is another picture of Rebecca. Isn't she cute? She's so pretty. And then this was a picture of her and the mom and stepdad. That's her mom and her stepdad. So it just goes to show you that how much nurturing and the home that you're brought up in can affect how you turn out. Because you would never know that she was the offspring of that lady. So I want to jump over and read the latest things on Aaron Spencer's docket. is it? That's not the right one. County, sorry. I have to remember how I look all these cases up because they're all listed in their court records differently, you know, depending on what state or county you're in. So it's like none of them are, no two counties or states are the same. So I have to keep track of who's in what county and who's in what state. And it's really confusing. I don't know how the other true crime people do it, but it's hard to do. I mean, I give them all the praise in the world because I'm telling you, it's not easy. Okay. I've never had this hard of a time finding something in the Aaron Spencer case. I don't know what's going on. Just 1 second. Okay, Aaron. Okay. This first one says order other, so and I haven't looked at any of these, so I don't know what any of them are, so we'll find out together. Okay. Get my highlighter. Okay. In the Circuit Court of Lonoke County, Arkansas, State of Arkansas versus Aaron Spencer. Order denying extensions of time on filing motions and responses. Before the court is the party's request for extension of time to file motions and responses. The court has previously granted extensions to both parties and has provided ample time for the filing of all pretrial motions. The court finds that the deadlines previously set were reasonable. Number two, the parties have already received sufficient time to prepare filings. Number three, further delay would impede the orderly administration of justice and the time resolution of the matter. Number four, no good cause has been shown to justify any additional extension. The request for any further extension of time to file motions, responses, or supplemental materials is denied. It is so ordered. Barbara Elmore. So there you have it, people. Okay, so let's move on to the next one. Brief in support. This is the state's brief in support of the state's response to defendants. to exclude evidence. Okay, is it going to show? Okay, so in the Circuit Court of Lonoke County, Arkansas, 23rd Judicial District, 1st Division. State's brief in support of state's response to defendants to exclude evidence concerning cell phone tower data. Comes now the state by and through Deputy Prosecuting Attorney Christine M. Hendrickson, and in its brief in support of state's response to defendant's motion to exclude evidence concerning cell phone tower data, states. Introduction. The defense alleges that cell phone location data is inaccurate and should be excluded from evidence. Well, if you watch the Karen Reed case, that's true, and if you watch the Brian Walsh case, it's not true. So, however, the use of historical cell site analysis has now been deemed firmly established and reliable by numerous courts across the country. Well, they may have to change that opinion after everything we heard in the Karen Reed case. Argument. The state previously filed a notice of expert testimony and listed Special Agent Blake Downing with the Federal Bureau of Investigation as an expert on cell phone tower location data. Special Agent Blake Downing has been previously testified in this court and certified as an expert and permitted to testify regarding cell phone tower location data. In addition, he has been certified in other Arkansas counties and testified 7 times in Arkansas cases. Has he testified anywhere else across the U.S.? Special Agent Downing has testified in over 25 cases across the nation. Wow. As an FBI agent, that is an expert in cell phone tower location data. The defense alleges that the information does not provide a precise location based on the now well-established principles of historical cell site analysis and the general acceptance of this type of testimony by courts across the country. There is no need for a Daubert hearing, and the evidence should be admissible. There should always be a need for a Daubert hearing if somebody requests it. I think. It's just my opinion. Courts have broad discretion to allow expert testimony concerning historical cell tower analysis because the technology and scientific principles used by cell phones to communicate with one another are valid, reliable, and fairly easy to understand in layman's terms. Okay, I strongly disagree with that. Fairly easy to understand. Okay. How many times was it explained to us in the Karen Reed trial, and I still don't understand any of it? I thought maybe I would when they got brought up in the Brian Walsh trial. Nah. The admissibility of expert testimony is governed by Arkansas Rule of Evidence 702 and the framework established by the Supreme Court in Daubert. Beginning in 1993, the Supreme Court provided trial courts with guidance on admission of expert evidence at trial. In Daubert, the Supreme Court established a 2-pronged test for the admissibility of scientific evidence. The first prong rejected the widely used quote-unquote general acceptance test enunciated in Fry v. United States. decided a half century before the federal rules of evidence were adopted in favor of a more flexible standard that reviews the scientific validity and reliability of the evidence. The second prong, sometimes referred to as the quote-unquote relevant, reiterated that scientific testimony or evidence must assist the trier of fact to be admissible. The trial court has broad discretion to determine whether to admit expert testimony and will not be reversed absent a clear abuse of discretion. Beginning in 1993, the Supreme Court provided trial courts with guidance on admission of expert evidence at trial. In Daubert, the Supreme Court established a two-prong test for the admissibility of scientific evidence. The first, we already went over that. Did they put that in there twice? They did. Okay. The Supreme Court in Daubert listed 4 non-exclusive factors that are helpful to determine the reliability of scientific or technical testimony. 1, whether the scientific theory or technique can be and has been tested. 2, whether the theory or technique has been subjected to peer review and publication. 3, whether a particular technique has a known potential rate of error. And 4, whether the theory or technique is generally accepted in the relevant scientific community. The court noted that these factors do not constitute quote-unquote definitive checklist or test, and that quote-unquote many factors will bear on the inquiry that involves a preliminary assessment of whether the reasoning or methodology underlying the testimony is scientifically valid, and of whether their testimony is methodology properly. Start that whole thing over again. The court noted that these factors do not constitute a quote-unquote definitive checklist or test, and that many factors will bear on the inquiry. That involves a preliminary assessment of whether the reasoning and methodology underlying the testimony is scientifically valid, and whether that reasoning or methodology properly can be applied to the facts in issue, end quote. The inquiry to be undertaken by a trial court is, quote-unquote, a flexible one, focusing on the, quote, principles and methodology, end quote, employed by an expert, not on the conclusions reached. Expert testimony, like all other admissible evidence, is subject to testing by vigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof. The state provided Special Agent Downing's preliminary report to the defense. Special Agent Downing is waiting on AT&T and Life 360 to respond to search warrant on the Fossler phone's location data to complete his report. The defense moved to have the court exclude any supplements of data and any expert testimony at trial. However, Arkansas Rule of Evidence 703 and 705 do not require the state provide facts or data prior to a hearing. Prayer for relief. Wherefore, the state of Arkansas respectfully requests that this honorable court deny the defendant Aaron Spencer's motion to exclude evidence concerning cell phone tower data. Respectfully submitted, prosecuting attorney. So there's that. Okay. So now I gotta. Oh, they added some more too. Wow. So this is a supplemental brief accompanying Just 1 second. Okay. I want to share this. I'm not going to say anything because I don't want to jinx myself. To wait till I'm done. Okay, so this is the supplemental brief accompanying reply in support of defendant's motion in limine to exclude evidence. The defendant, Aaron Spencer, through his attorneys Aaron Casanelli and Michael Kaiser, submits this brief accompanying supplemental reply in support of his motion in limine to exclude evidence. Footnote 1. Pursuant to the court's November 17, 2025 order on briefing, Spencer refiled his original motion in limine and reply, along with their accompanying briefs, on November 24, 2025. When the state refiled its responsive pleadings that same day, it added arguments that had not appeared in the original response. This supplemental reply and supporting brief address those new arguments. Spencer incorporates his previously filed briefs by reference as if fully set out herein. Summary: the state builds its entire case theory on one frustrated mid-conversation utterance, quote-unquote bullshit. From a single expletive, the state extrapolates motive, intent, plan, and personal ideology, projects a future mental state, and nullifies Fossler's behavior, and attempts to extinguish the justification defenses. It is a remarkable house of cards built on a foundation of quote-unquote bullshit. Wow. Spencer has already exposed the state's factually discordant account in his November 24, 2025 briefing. Rather than correct course, the state repeats that same narrative verbatim in its new response and simply layers on new arguments about relevance, probative value, and admissibility. None withstand scrutiny. The relevant law. Spencer is charged with the second-degree murder of Michael Fossler pursuant to Arkansas Code, and then it gives us the case number, or the page number, which requires proof that he knowingly caused Fossler's death under circumstances manifesting extreme indifference to the value of human life. Spencer has asserted two statutory justification defenses to this charge. First, Spencer asserts deadly force justification under, and it gives the code for that law, in defense of his daughter and himself. The statute provides that a person is justified in using deadly physical force if he reasonably believes the other person is 1, committing or about to commit a felony involving physical force or violence, 2, using or about to use unlawful deadly physical force, or 3, imminently endangering the person's life or imminently about to victimize the person from the continuation of a pattern of domestic violence. Spencer has also asserted a choice of evils defense. I've never heard of that. Conduct that would otherwise constitute an offense is justifiable when the conduct is necessary as an emergency measure to avoid an imminent public or private injury, and number 2, according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweigh the injury sought to be prevented by the law proscribing the conduct. Reasonably believes, or reasonable belief in Arkansas Code. As a belief, 1, that an ordinary and prudent person would form under the circumstances in question, and 2, not recklessly or negligently formed. To convict, the state must prove beyond a reasonable doubt that Spencer knowingly caused Fossler's death by deliberately creating a risk that was practically certain to result in Fossler's death. So he set up the situation to where his daughter would be kidnapped and SA'd again and re-victimized just so that he could kill Fossler? I don't think so. That sounds ridiculous. The state must also prove beyond a reasonable doubt that Spencer did not act under a reasonable belief that Fossler was committing or about to commit a felony involving force or violence. Really? Or using or about to use unlawful deadly physical force against Spencer or his child, and that Spencer's conduct was not necessary as an emergency measure to avoid an imminent harm, and that the desirability and urgency of avoiding that harm did not outweigh the injury prescribed by the murder statute. Wow. I'd like to see if their opinion changed if it was their kid. All justification defenses must be submitted to the jury if any evidence supports them, and the jury must be instructed that any reasonable doubt on any of them requires an acquittal. Thus, once raised, the state must disprove these defenses beyond a reasonable doubt. By statute, a justification such as self-defense is considered an element of the offense, and once raised, it must be disproved by the prosecution beyond a reasonable doubt. Argument 1. An expletive is not relevant evidence. The state argues that a frustrated, quote-unquote, bullshit Spencer uttered in July of 2024 somehow reflects his, quote-unquote, extrajudicial mindset months later on October 8, 2024. State Resp. at 4. I don't know what that means. The state claims this remark shows that A, he acted with the prohibited mental state on October 8th, and B, he did not act with reasonable belief required for justification. But this testimony would not assist the jury in determining what an ordinary, prudent person would think is reasonable under the justification statute. If the jury finds that a defendant reasonably believed he or his child faced imminent physical harm and the other statutory conditions are met, the justification statute requires acquittal. Woo! Even if the defendant acted with a culpable mental state. Wow, that's crazy. The state's proposal to use a single expletive to show that Spencer did not act with reasonable belief risks confusing the jury because the statute applies an objective standard, not a retrospective psychoanalysis of the defendant's moods months earlier. And the suggestion that one midsummer conversation dictated Spencer's mindset 3 months later stretches credibility past its breaking point. Spencer's mindset on October 8, 2024 was shaped by the circumstances Fossler created that morning. Yep. If he wouldn't have showed up and kidnapped Spencer's daughter, we wouldn't be here. Not by an offhand remark in July. Which is more likely to have caused or dictated whether Spencer was going to kill Fossler? What he said 3 months ago when he said that the law's bullshit, or when he found out, when he passed Fossler with his daughter in his truck in the middle of the night after finding that she was missing from her bed? Okay. Whether the jury concludes Fossler forcibly kidnapped Spencer's 14-year-old daughter or groomed her so he could continue abusing her, if not disappear her entirely, which I think that's what he was going to do, the analysis is the same. Either scenario created legal justification and certainly reasonable cause for Spencer to act to protect his child from a sexual predator who refused to stay away from her. He had no, the courts orders, so what's Spencer supposed to think? If he's going to be that blatant and that blatantly disregard the court's orders, I mean, Spencer's not going to take a chance. The state's position boils down to this. If Spencer thought his 14-year-old daughter might have gone willingly with her abuser, Arkansas law required him to stand aside and hope for the best. What? That is not the law. It is offensive to common sense, to the text of the justification statutes, and to the protective duties Arkansas law recognizes when a child is in danger. What Spencer said months before does not matter and is not relevant. What matters is what happened on the morning of October 8th, 2024, when Fossler, by his own choices, presented an imminent threat of harm to his victim, and when Spencer had every right and indeed every obligation to act to save his child. Roman numeral 2, inflammatory rhetoric has no probative value and is highly prejudicial. The state offers a novel argument that a single expletive can be sufficiently versatile to prove Spencer's motive, intent, and absence of justification in a crime committed months later. And that is overwhelming probative value later. And that it's quote-unquote overwhelming probative value for far outweighs a negligible risk of unfair prejudice. The state's reliance on Demas Martinez v. State is puzzling. That case bears no resemblance to the situation here. In Demas Martinez, ammunition found in the defendant's vehicle a month before the murder was admissible because it matched the .380 ammunition used in the homicide. Likewise, the .380 firearm the defendant urged a third party to retrieve, though not conclusively proven to be the murder weapon, was admissible because it showed his access to a .380 caliber gun at the time of the crime. In other words, both pieces of evidence had clear specific physical connections to the murder weapon and were independently relevant to proving the defendant's access to it. The state misrepresents Demas Martinez by claiming that the evidence there showed the defendant's preparation, planning, motive, or intent. It did not. It showed access to the gun and ammunition used in the murder, nothing more. That evidentiary link is what justified admission. I don't know what that means. There is no comparable link here. Spencer's July statements have no connection, temporal, factual, or logical, to the charged conduct 3 months later. Those statements addressed a hypothetical situation, a P who even after arrest reoffends, and the right of a person to protect themselves and others from such an attack. Nothing in that conversation supports the conclusion that Spencer planned to kill Fossler months later, let alone the state's extraordinary suggestion that Spencer intended to allow Fossler to assault his child as part of that supposed plan. Simply put, Demas Martinez involved evidence directly tied to the murder weapon. The state's attempt to equate that with a frustrated remark in a hypothetical discussion about protecting children is legally and factually untenable. Even more concerning, the state argues that the remark shows Spencer's explicit contempt for the prohibition on vigilante justice, extrajudicial mindset, and personal code, philosophy of lawlessness, and its vigilante ideology. These terms meet the very definition of propensity, an inclination or natural tendency to behave in a certain way. This is exactly the type of information prohibited by Arkansas R evidence. Evidence of a person's character or character trait cannot be admitted for the purpose of proving he acted in conformity with it on this particular occasion. So, evidence of a person's character. Moreover, courts have recognized that vigilante rhetoric is a classic appeal to passion that risks inflaming a jury and constitutes prosecutorial misconduct. What? Are you kidding me? The same danger arises here. The term carries an emotional charge wildly disproportionate to any productive value the state claims to extract from a single frustrated expletive uttered months before the incident. Allowing the state to frame the case around loaded character judgments rather than evidence would invite precisely the unfair prejudice Rule 403 prohibits. For these reasons, the July statements are inadmissible under Rule 403 and 404. The court should exclude the challenged evidence and prevent the state from advancing argument premised on an inflammatory vigilante rhetoric. Roman numeral 3. Rule 404B bars admission of this evidence. In its amended response, the state concedes that it seeks to introduce character evidence to show that Spencer acted in conformity with that character trait, vigilantism. So they're trying to say he's a vigilante. Recognizing vigilantism as a character trait is subject to Rule 404. The state argues that it was vigilante ideology that drove Spencer's actions. Such evidence is inadmissible under 404A1 unless the defendant first places his character at issue, which Spencer has not. It is likewise barred by Rule 404B, which prohibits using other acts or purported character traits to prove action in conformity with that character. The state initially appears to recognize this bar, asserting that the statements it seeks to introduce are not, quote, evidence of other crimes, wrongs, or acts, end quote, but merely expressions of belief. Yet in the next breath, the state insists that these same statements are admissible under various 404B exceptions. The state cannot have it both ways. Having conceded that the statements are not Rule 404B evidence, it cannot invoke Rule 404B's exceptions to justify their admission. And even if the court were to construe the statements as 404B evidence, the state never explains how a single frustrated utterance satisfies any of the exceptions it lists. There you have it. They want their cake and eat it too. Moreover, Rule 404B evidence is admissible only if the prior act and the charged conduct bear sufficient similarity to satisfy Rule 403. The state does not attempt to explain how expressing an opinion, however colorfully phrased, in a conversation with a third party bears any meaningful resemblance to Spencer's defense of himself and his child against a violent predator. In short, the state's theory fails under Rule 404A, fails under Rule 404B, and collapses under Rule 403. Conclusion: for all these reasons, the July statements are not relevant, not admissible, and not productive of anything that the state claims they prove. They do not illuminate Spencer's mental state on October 8, 2024. They do not undercut the justification defenses, and they have no similarity to the charged conduct that would permit admission under Rule 404B. What they offer in prejudice dwarfs anything they could conceivably contribute in probative value. Accordingly, the court should exclude the challenged evidence in its entirety and prohibit the state from advancing arguments premised on inflammatory vigilante characterizations or other impermissible uses of the July conversation. Wherefore, the defendant, Aaron Spencer, asked the court to grant the defendant's motion in limine and for any other relief the court finds appropriate. So there. I mean, wow. Is it all prosecutors that try to pull, a fast one on defense by trying to get things ruled both ways for them? It just seems like it is. Because I don't know, they all seem dirty. All prosecutors seem dirty to me for some reason. So, what's this one? Let me see. This might be the same thing. Yeah, that's the same one. That's just a shorter version of what we just did, what we just went over. Okay, and there's one more thing, I think. And they served another subpoena today. It doesn't say on who. Order regarding, there's an order that was put out today for courtroom security. This is the last new filing. Okay. Order regarding courtroom security. On the court's own motion, and in order to ensure the orderly administration of justice and the secure and efficient operation of the courtroom, the court issues the following directive regarding security arrangements for the upcoming proceedings in this matter. It is hereby ordered that the Lonoke County Sheriff's Office, including the deputies, its employees, and assigned personnel, shall not provide courtroom security for proceedings scheduled in the above styled case. This directive is issued solely for logistical and administrative reasons concerning courtroom security management. Alternative security arrangements will be made by the court for the hearings and trial in this matter. The Sheriff's Office shall otherwise continue to fulfill all duties not inconsistent with this order. It is so ordered. Barbara Elmore, Circuit Judge. La-di-da-da. So, that basically sums it all up. That's all I have for tonight. I appreciate everybody showing up, and I want to thank you all for continuing to watch my content. Not a lot of you, but hopefully that improves. What else? I think that's about it. I'm off this weekend, so I can't wait. I'm gonna do all the the decorating and whatnot. My husband and I built a giant. He owns a BMX bike shop, and he has a BMX racing team. He races, and so we made a Santa sleigh, and he's using little baby BMX bikes as the reindeer, and we're gonna put that either on top of our house or the front yard. It's quite big. I was surprised at how big the sled turned out, but I'll have to post pictures, and it turned out really good. I'm really, really, really happy with it. I can't wait to see it up. So anyway, I hope you guys all have a good evening. Stay safe, and peace out.